and welcome to another one of our Farm Transition Workbook video series presentations. In this presentation, we're going to be talking about what are called non-probate transfer tools. And that may sound kind of intimidating, but when we say this, what we really mean is tools that pass property after you've died without having to go through the probate process. And the most commonly thought of non-probate transfer tool would be the trust, and we've talked about that in a separate video. We're going to talk about some other tools besides the trust today that accomplish some of those same goals. Now, when we exclude trusts, some of the other big tools that are out there that we could use include transfer on death deeds. And these are deeds that are specifically provided for in Oklahoma statute that transfer real estate. We could also talk about beneficiary designations on many kinds of investment accounts. We can also talk about life insurance, which, if you think about it, is a contractual tool arranged to transfer wealth at some point after your passing. So let's talk about each one of these tools in turn. The Oklahoma Non-Testamentary Transfer of Property Act created the transfer on death deed. You might also see that sometimes called a TODD or a TODD. But basically, the way that this tool works is much like a regular deed. You record a transfer on death deed in the county land records, and the advantage of this is that you don't have to go through the process of a will and also don't have to go through the probate process to transfer this property. The deed functions to transfer the property. The only difference is that that deed only takes effect when you die. Now, since this is another contractual tool, it doesn't have to go through the probate process, and lots of people like the tool for that very reason. That saves them a lot of time and potentially some expense in transferring that property as well. When we talk about how do you use a transfer on death deed, number one, you're going to execute a deed. And part of the provisions of that deed are going to be that the property is only transferred at the time that the grantor, in other words, the person executing the deed, dies. So once that death takes place, then and only then does that property transfer actually have legal effect. Once the deed's been prepared, the deed has to be both signed and notarized by the person that's granting the property. Next, that deed has to be recorded in the county land records for the county in which that land is situated. And, very importantly, that deed has to be recorded prior to the death of the grantor. In days past, before we had the transfer on death deed, what many people would do is execute what was called a desk drawer deed. They would execute a deed to the person that they wanted to receive the property after they died, but then they would put that deed in a desk drawer or somewhere else and tell the other person, when I die, get this deed out and go record it. That actually created a lot of problems. First and foremost, among them was the fact that under Oklahoma law and the law of virtually every other state's deed has to have present effect. In other words, the deed must be effective and transfer its interest in property the moment that it's executed. If that's delayed, especially if it's delayed contingent on some event like a death, the deed's ineffective, it's invalidated, and that land basically fell to intestacy. So the Transfer on Death Deed Act specifically overrides that rule and allows that a deed can have effect after someone dies, but the trade-off for that is that the deed has to be recorded before the grantor dies. Now, if we execute a transfer on death deed successfully, we have to remember that there are still a few strings attached. Number one, the deed can still be revoked. In other words, the person that's granting the interest, the grantor, can change their mind, and they can direct that property goes to someone else, or they can just dissolve it and bring the property completely back to themselves by executing a revocation deed or a subsequent different deed. So just because a transfer on death deed has been recorded, that doesn't mean that the interest is gone forever. You still retain ownership of the property until the moment that you die, and you also still have the right to change who would receive that property or just to erase that designation entirely. The counter argument to that, or I should say the flip side to that, is that it does not convey any interest in the property until death. If we were talking about a life estate, the life estate carries with it some limited right to influence the current owner's behavior with respect to the property. For example, if we create a life estate, and that means that one person currently holds a life estate and another party has what we call the remainder, in other words, the interest in that property after the life estate holder passes away, and they notice that the life estate holder is causing damage to the property, they can basically sue for an injunction or other sorts of legal relief to get the person currently holding possession of the property to stop causing that damage and to preserve the value of what they're going to receive. There's no such interest created with a transfer on death deed. The person that owns the property has an absolute right to do whatever they want to with it until the moment that they die and that interest transfers. Also, it's important to note that a transfer on death deed does not reduce estate tax liability. As we've talked about in other videos, your estate tax is calculated based on the amount of property that you own or control at the moment that you pass away. And some people think that by executing a transfer on death deed, that they're transferring property out of their estate and that won't be counted in valuing their estate to determine whether or not they owe any estate tax. That's not true, specifically because you still retain control of this property. In other words, remember, like we just said, you can revoke this transfer on death deed at any point in time. That property is still within your estate. So using a transfer on death deed is not going to establish any sort of reduction in your estate tax liability. If there's a conflict between your will and the transfer on death deed, the transfer on death deed is going to prevail. In other words, you can't revoke a transfer on death deed by a will. You can revoke a transfer on death deed by executing a subsequent deed or a modification like we just discussed, but you can't revoke the transfer on death deed by a will. So it's very important that you reconcile your transfer on death deed and coordinate it with your other estate planning documents. Also, you cannot use a transfer on death deed to defeat joint tenancy. And we've talked about joint tenancy in other videos as well, but just very briefly, remember that when we have two joint tenants, and you can have more joint tenants, by the way, but let's say, for example, we have two joint tenants. One joint tenant passes away, their interest automatically transfers to the remaining joint tenant. It would work a legal problem if we allowed someone to execute a transfer on death deed that would deprive another joint tenant of the interest they would be entitled to when that joint tenancy matures. So if you're going to execute a transfer on death deed, you would basically have to have all of the joint tenants join into that, which would essentially destroy the joint tenancy. So it's really difficult, if not impossible, to transfer joint tenancy property with a transfer on death deed. And legally, it's probably just better to avoid using that tactic entirely. Let's say that you have received an interest via a transfer on death deed. What do you need to do? Well, first off, what you're going to need to do is you're going to have to file a notarized affidavit with the county clerk's office. And there are a few items that have to be included in that affidavit. Number one, you're going to have to verify that the owner of the property, the grantor, passed away. That fact has to be stated in the affidavit. You're also going to need to indicate whether or not you were the grantor's spouse at the time that they passed away. And you're also going to have to provide a legal description of the property. Basically, information that confirms the death of the grantor, establishes your relationship, and allows the clerk to confirm that the property that you're describing in the affidavit is the property that was also described in the transfer on death deed. In addition to all of this, you're also going to have to provide a death certificate to the county clerk. So make sure that you have both the affidavit and the clerk prepared for filing so that you can actually go ahead and claim the transfer on death deed interest. An important reminder is that all of this documentation has to be provided to the county clerk within 9 months of the owner's passing. If the property is not claimed by the filing of the affidavit and the death certificate within 9 months, then the property is deemed to be intestate and would revert back to the estate of the grantor. And that's a circumstance that most of the time we would definitely want to avoid. So make sure you make all those filings in a timely manner. So that's the transfer on death deed. Let's talk about beneficiary designations for a second. Beneficiary designations show up in a large array of shapes and sizes, so to speak. The most frequent place that you see beneficiary designations is if you have some sort of an investment account. And probably the most frequent example that we see of this is when you have a retirement account through your employer, maybe a 401k, IRA, or some similar form of plan. With that plan, you often have the opportunity to designate a beneficiary. In other words, if you die while the investment is being held by the managing company, they agree that they will pay the proceeds of the investment to the person that you designate as the beneficiary. So this can be a wonderful tool. It can be very inexpensive and very effective because, again, since this is a non-probate transfer, the investment doesn't have to go through probate. It can be paid directly to the person that's receiving it. So when you're talking about the considerations of a beneficiary designation, number one is it available? Does the person that's administering my investment asset offer a beneficiary designation? Also, we need to make sure that we stay on top of our beneficiary designations. If something changes, for example, let's say we get married or divorced, or maybe we have a child or a child passes away, we need to make sure that we go back and review those beneficiary designations to make sure that they reflect what our current wishes are. For example, let's say that we started a job before we got married, and in that circumstance we could have designated that our beneficiary be our parent or a sibling or maybe a favorite charity. After we get married, we may have wanted to change that to our spouse, but if we don't go back and actively do it, that's not going to automatically change. So we need to make sure that we constantly review those and make sure that they're as current as we need them to be. We also need to ask ourselves, with respect to the investment asset that we're dealing with, is a beneficiary designation the way that we want to use or transfer that asset? Or is there another tool that we prefer to use, maybe a trust or a will to designate that asset? And that there's not a right or wrong answer. What we're just saying is that we need to make sure that we carefully coordinate our beneficiary designations with our other estate planning tools as well. Closely related to the beneficiary designation is a payable on death designation. And when we're talking about a POD designation, the most frequent place you'll see this is with a bank account. With a bank account POD designation, ownership of that account transfers to the person designated through the POD provision. And it's important for us to note that there are some sharp differences between a joint account arrangement and a payable on death arrangement. When we're talking about a joint account, we've made someone a co-owner of that bank account. So anyone listed as on a joint account has full access to the entire amount of that account immediately. It doesn't wait until we die. They are very presently a co-owner of that account, and that has consequences for us. For example, that account is available not only to them, meaning that they could withdraw all the funds and use them however they saw fit, but also their creditors would have access to that account as though it were entirely that of the joint account holder. So many people have good intentions in establishing a joint account arrangement, but there can be some unintended consequences, and it's just important to note that that joint account holder now is basically equal with us in terms of account ownership even before we die. The differences then with the payable on death account are that the POD designee does not have any interest in those funds until the primary account holder passes away. They can't access those funds aren't accessible to their creditors, they have no interest in those funds until the primary account holder passes. And that can be a very important protection for lots of people that have intentions of transferring the contents of that account, but only when they pass away. The last non-probate tool that we're going to talk about in this video is life insurance. And life insurance can be an investment, it can be an estate planning tool, it can be a non-probate tool. It's got lots of different uses. And we'll just talk about some of those uses fairly quickly. Number one, of course, is probably the use that most people think of, and that is to create a source of income for dependents in the case that someone dies unexpectedly. Especially with young families, if you have two wages in the household and it's very important to have both of those wages to support the family, the sudden loss of one of those could be a catastrophic financial circumstance. And so having income provided for by the life insurance proceeds could be very important to that family. If there are large unexpected medical expenses, life insurance could be used to kind of clear those debts and make sure that the estate isn't burdened by any unpaid medical bills. You know, the most recent research estimates show that if a person age 65 can expect to pay $250,000 out of pocket for their remaining lifetime's medical expenses, and that's even excluding Medicare and other forms of payments. That's $250,000 out of pocket. That can be a pretty significant blow to the assets of lots of retired individuals, and so life insurance may be an important tool for them with respect to those medical expenses. If we have a farm operation that still has some debt on the books, we have to remember, as we've talked about in the workbook and in other videos as well, that that debt doesn't go away when the person that incurred the debt passed. We still have that debt out there, and so to avoid burdening the estate or the remaining farm operation, life insurance proceeds may be needed to pay off those debts and provide a clean slate. Estate administration costs, the costs of attorney's fees, final funeral expenses, all of those are items that proceeds from life insurance might be used for. Providing additional liquidity for the farm operation after a primary wage earner is gone might be very important for exactly the same reason as we talked about in point 1, just by analogy to the farm operation rather than the family. If we anticipate that there might be significant estate taxes to be paid by the estate, life insurance proceeds might also be used to pay some of those estate taxes. It's important to note while we talk about this, though, that this requires very careful coordination with your attorney and your tax professional, because you don't want to exacerbate the problem of the value of the estate by paying life insurance proceeds into the estate. That can actually make the valuation problem worse. So talk to your attorney, talk to your tax professional, and make sure that you're very clear about who pays the proceeds for the life insurance policy and who owns the life insurance policy to minimize those risks. If there's been a remarriage involved and we have children from a first marriage that may be actively involved in operating the farm, along with a spouse, surviving spouse, that may not be their parent, we might want to have a buy-sell provision in our transition plan that allows either the children to buy out that surviving spouse or vice versa, simply because depending on the family situation, it may be difficult or awkward for those two groups to operate the farm together. That's something that we could talk about a lot more in the family communications videos, but that's one issue that we might want to address. Last but certainly not least, we've talked in other videos and in the workbook about the farm kid, city kid problem. In other words, what if we have one heir that wants to come back to the farm and operate it, and we have other heirs that might not want to come back, but we still want to provide them some sort of financial benefit when we die. Life insurance is one tool that might be capable of helping us with that. We might choose to just give directly to an off-farm heir life insurance proceeds. That way they get a little bit of the financial value of the estate without having them involved in the day-to-day operations of the farm. Sometimes on-farm heirs might choose to take on life insurance for a parent if they foresee that they may have to buy out siblings in the future as well. With respect to all of these potential uses of life insurance, be sure to talk to, again, your attorney, your tax professional, and talk to a trusted financial advisor as well, because there are many, many different kinds of life insurance products out there, and not all of them are going to be suited for all of the purposes that we've talked about. Be very selective and very cost efficient when purchasing your life insurance, and you can avoid creating any more of a drain on your financial assets. We've talked about quite a few things in this short span of time. We've talked about the transfer on death deed and how we can use it to transfer real property at death outside of the probate process, and for some people that prospect has a lot of appeal. We've talked about beneficiary designations and TODD accounts and how those can transfer investments, bank accounts, and other forms of financial assets when we pass away, again without having to go through the probate process. And we've talked about life insurance and the flexibility that it has as a transition planning tool as well. The moral of the story is, with respect to all of these tools, take into account all of the other transition planning tools that you're using. Make sure they all coordinate and mesh well. Make sure that they all have a place to play in your farm transition plan. And if you need more information about any of these topics, or just general information about the farm transition concept, be sure to visit our website. That's agecon.okstate.edu/farm transitions. One more time, that's agecon.okstate.edu/farm transitions. And thank you for watching.